I have not. When was
Okay.
it sent?
About half hour ago, I believe. Is that right, Ms. Hartman?
I will defer to Ms. Crawford on that. I'm not sure exactly. Yeah, it's about an hour ago,
Okay.
Okay.
judging by my email.
I mean, Your Honor, I get. I'm sure they're going to paraphrase what it is. It basically was dealt with an initiative on the last election dealing with judicial retention. You might remember it, and basically it dealt with the language from that ballot as to what would happen if the judicial retention proposition would have passed. Or that the ballot language that was put up there, and I just would like for the record, and happy to file something, and we do plan to file another notice of supplemental authority too. I just want to put that on your radar. But the reality is that ballot language that they gave you actually supports our case, and because it is mirroring what was actually inside the referral. It specifically discussed that it would impact the retention or the election of the judicial retention for that election. It's directly in the proposition. So a ballot language that summarizes the proposition and clearly says that it's going to impact the judicial retention for that election because it's inside the initiative is exactly the point we're trying to make. So I would ask Your Honor to take that into account and we'll get it to you. We'll file a notice of supplemental of what the initiative actually said, so you can actually see that the language was directly from the initiative. We'll also get you the legislative council language, which basically mirrored what the ballot said. And then, Your Honor, we'll file if you really want. I mean, we will give you some other examples because we went through many of the propositions for the last that are on the Secretary of State's website. We could not find any other ballot measure that made a reference to another ballot measure that outside of the context of this judicial retention, and obviously that wasn't a ballot measure confirming to another ballot measure. It was a ballot measure as to the retention of judges. So for your reference, Your Honor, the 2006 examples that we intend to file for you, one is 105 and 106, propositions 105 and 106 from 2006, dealing with the state land trust. And then same year, 2006, propositions 201 and 206 dealing with the smoking. Those were competing initiatives, okay? So, and they did not cross-reference each other. So this is the first time that we're aware of where a ballot measure cross-references the other ballot. Now, this gets into my other argument, and I don't want to repeat our filings by any means, Your Honor. I know that you've read them, and I want to make sure I'm answering your questions. But the judicial retention, that was actually impacting existing law, because existing law laid out the retention of judges. So not only was it inside the initiative, but it was actually changing existing law as to how those judges were going to be retained, which is our first fundamental argument that we have here with what the defendants have done. Because this proposition 212 that's cross-referenced 3 times in the ballot language is not existing law. And under 19-125D, it specifically talks about existing law. If you look at the Court of Appeals opinion in Lane and you look at the Supreme Court's opinion in Quality Education, they cross-reference the existing law. And then, that wasn't dealing with existing law. That then went into the second argument, which was false and misleading and argumentative. And that's obviously what we have here, Your Honor, is that the first fundamental issue for Your Honor's determination is the statutory interpretation of 19-125D and whether or not it has to make a cross-reference to existing law, or are you going to go through this extrapolation that the defendants have done to say, well, it could be existing law at the time that it's actually passed. That's not how that works. And if you look at the Lane decision from what Judge Foster, it was a unanimous, what the Court of Appeals said in Lane is that no, it has to be existing law. And in that case, basically there was a tax that was not going to be law. It made cross-reference to it. And the Court of Appeals said that that's not appropriate. So from fundamental issue, Judge, this is not 212 is not existing law. The other issue is that it's misleading, because the ballot, if you read the ballot, it sounds like just simply a blocking proposition to another proposition. That's not the case. It's saying that from the context going forward, that it's going to have an impact on law and that it can't be changed because it's a constitutional amendment. Now, we don't need to explain to the electorate the difference between a constitution and a statute, and that the constitution is going to trump the statute. That's not required. So there's no need to go down to some sort of analysis is that we're trying to tell. The reality is that 212 is not referenced. Now, again, they want to make a determination. You see the correspondence, we didn't hide it, with the correspondence between the defendants, or at least the Attorney General's office and our office, in regard to this back and forth. And the Attorney General tried or requested that we confirm what our interpretation would be if the ballot measure 145 were to pass, and what the impact would be if 212 would pass. And we believe that the case law, and we've cited it, that's just an inappropriate determination at this stage. The courts, the judiciary, we don't get it, or the judiciary does not get into the business of interpreting what law is going to be post-election. Instead, as Lane talked about and Quality Education discussed, it is purely a procedural process that we're in right now, a pre-election procedural process to basically call balls and strikes of whether the statute was followed. Again, 19-125, we believe that statute was not followed, and we believe that it's also misleading because it's not just limited to 212. 145 is not just limited to 212. So again, I don't want to take up your time in just repeating what the brief said. I did want to make sure we touched on the notice of supplemental authority. We will get you in the references that I just cited. Underneath, I'm blinking on the case law right now. The court can take judicial notice of what the Secretary of State has published previously in the election publicity manuals. I don't think that there's going to be a dispute on that, especially since they just filed one about the last election. So with that, Your Honor, I'm happy to take any questions you have. I thought the briefs laid out the arguments succinctly.
Okay. I'm going to reserve my questions until I've heard from both sides.
Yes, Your Honor.
Crawford, Ms. Hartman, which of you will be arguing next?
I will, Your Honor.
Okay.
So a typical ballot language case involves arguments that the Secretary didn't choose the best language. A challenger may argue that it's misleading, it's inaccurate, or it could be viewed as argumentative, partisan, etc. Here, the plaintiff's primary argument is different. They're saying that the Secretary cannot include accurate information about the effect of Prop 145 on another measure that appears on the same ballot. Now, that's a pretty remarkable position because we're dealing with a statute that is intended to state for the voters in plain English what a measure proposes and what the effect of voting yes or no on that measure would be. And plaintiffs have admitted that the effect of voting yes on Prop 145 and also yes on Prop 212 is that Prop 212 would be nullified. In their answering brief at page 2, they say, even if Prop 145 would void Prop 212 if both become law, this reality can be and has been conveyed to the public elsewhere in the ballot language. There's really no meaningful dispute that that's what this does. It's a proposed constitutional amendment, whereas the initiative is a proposed statutory amendment, and they are directly conflicting. It's also, Prop 145 is also retroactive, and it explicitly states it applies not just to laws enacted after November 1st, 2026, it applies to ballot measures approved by the voters. Not ballot measures once they become effective, but ballot measures approved by the voters on or after November 1st. So this is a really unique proposition that they put forward here. The court should reject their strained construction of this existing law theory because no court has ever held that this statute prevents the Secretary from including what is indisputably accurate information about the effect of Proposition 145. Now, this core existing law argument really takes the language out of context and it ignores the standard that applies here. There's a reasonableness standard. There is deference given to the Secretary and the Attorney General in this context. That's why our Supreme Court case law says as long as it's not clearly misleading or indisputably inaccurate, we have to step back and say, was this a reasonable attempt to convey the necessary and appropriate information? And this ballot language absolutely is. It's the Secretary's job to tell voters in plain English if you vote yes on this measure, here's what the law will be. If you vote no on this measure, here's what the law would be. And that's all the ballot language does. Importantly, I think it's true that it would be necessary to tell voters this, because if you don't do that, an average voter is not going to understand that if you vote yes on both measures, you are negating your yes vote on Prop 212. That is not readily clear from these lengthy terms. And I would say even the average lawyer would have to go do some digging to really understand that. So this is well within the discretion and very reasonable to do in the ballot language. You also have to read existing law in context. All existing law means is to put a limit and say, well, the Secretary and the Attorney General aren't going to opine on how it might affect future laws or unresolved legal questions. That gets at things like Malera, which the plaintiffs rely on pretty heavily. In that case, they said, well, you don't need to include information about the constitutionality because that's not the sort of thing we put in ballot language. We don't say, hey, this might be unconstitutional, because whether a law is constitutional or not has nothing to do with whether the legislature or the voters can pass it. That's why that has to wait until the end. Really, what existing law means is what is going to happen if you vote yes or no. And that's what the ballot language does here. Now, we filed this notice of supplemental authority about Proposition 137 about an hour ago, and I'm happy to share that language on my screen if the court and opposing counsel will be able to view it.
It's not necessary for my benefit. I will review it as soon as this hearing is concluded.
Okay, thank you, Your Honor. So in that proposition, it was a legislative referral to the voters where the referral was going to amend the Constitution to change the rules for judicial retention. And the actual amendment language itself did not say anything about nullifying the concurrent vote on judicial retention. It did include a section that said that it would have retroactive effect and therefore nullify votes on retention that happened on that ballot. But that was not in the language of the proposition to amend the Constitution itself. Notably, the yes-no language, which is the language that describes the effect on existing law, not the descriptive title. The descriptive title also talked about how this would nullify any votes cast for retention of judges at the same election, but also in the yes-no language, where under the statute, as plaintiffs make a big deal about, you need to say the essential change in the existing law should the measure pass. It's stated, if approved, these amendments will apply retroactively such that the votes cast in the November 2024 election about whether to retain a judge will not be given effect. Under plaintiffs' own theory, that would violate their reading of existing law because that is not in existence. This is stating ballot language about something that may happen in the future. At the date of the election, they may vote yes or no on whether a judge is going to be in or out. Really what this boils down to is, does it give the voters the necessary and appropriate information? And it absolutely does. I'd also like to point out that their arguments about rightness really miss the mark here. Again, the ballot language is not opining about the constitutionality or downstream effects of what Prop 145 will be. And in fact, under plaintiffs' theory, their own case would be unripe and moot because Prop 145 has been ruled unconstitutional and is at this moment not on the ballot. So I really think that's a red herring and it should not take too much of the court's time. I also want to make clear that we're not asking the court to decide or declare what existing law means in the abstract. That's a really difficult question. What we're asking the court to do here is decide the question for it, which is the ballot language that has been developed for Proposition 145. Is that a reasonable attempt to provide necessary and appropriate information to the voting public? What's necessary and appropriate is going to vary on the circumstances and the particulars of the various proposals, just like it does here. The only reason the ballot language needs to and is appropriately does mention Prop 212 is because Proposition 145 was written to retroactively nullify not just laws enacted, but measures based on the same ballot. Again, it says it would void any bill enacted into law or a measure approved by the voters on or after November 1st, 2026. Doesn't say in effect, doesn't say law enacted by the voters. It says a measure approved by the voters as of the moment that a voter checks yes or no. There's only one measure on the ballot that's within that scope of retroactive nullification, and that is Prop 212. So they make a big deal about the fact that it references Prop 212 specifically, and it calls it out by name and describes the subject. That doesn't indicate anything partisan or argumentative or biased. It's just a simple fact that the Secretary and Attorney General must prepare ballot language that plainly states what the provisions are about and what they would do. The fact that we were presented with two propositions that both deal with scholarship accounts, which includes and ESAs, is just a fact. There's nothing partisan or misleading about that. Lastly, I'd like to point out that the case law actually supports us. Number one is Lane. So they rely heavily on Lane, but I find that a bit confusing because under their theory, Lane seems like it should have come out differently. Because Lane, the ballot language was struck down because it said a proposed tax would replace and reduce an existing tax, when in fact, that existing tax would expire right before the election, and the proposal would be adoption of a new tax. So it would go from 0.2% to 0.15, but it wasn't a reduction because in fact, what was going to happen is it would go from 0.2 to 0, then up to 0.15. Now, if you were taking existing law as of the time that the ballot language was drafted, the existing law in place at that time was a 0.2% tax. That was what the court found problematic. On the date that the voters would be deciding whether to adopt the new 0.15 tax, the tax rate would be 0. So they were looking at it as of that date. That's exactly what we're doing here. Prop 145 says we're concerned about measures approved by voters on or after November 1st. We are dealing with Prop 212, a measure that is before the voters for approval after November 1st, 2026. How is also really helpful for illustrating why the court doesn't need to get into debating whether some language is better or best for this ballot language challenge. In that case, the issue was a voter initiative that had allowed doctors to prescribe certain controlled substances for medication purposes. And challengers brought a claim saying that the Legislative Council analysis and the ballot language were incorrect and misleading because they included examples of drugs that would be covered that were those that might affect the voters and elicit some kind of response, for example, heroin. The court specifically rejected the argument that the secretary should have used less triggering alternatives, such as controlled substances or Schedule I drugs, without examples or explanations, e.g. heroin, because it would not fairly apprise the voters of the proposition's contents. The same is true here. They say, well, we already say that it would nullify it because we described that it has this broad nullification provision. But that wouldn't fairly apprise voters that if you check yes on both of these propositions and both pass, you have negated your vote on Prop 212. Finally, I would just note mandamus relief is not available. They haven't cited a single ballot language challenge case that ordered mandamus relief. And so we don't think that is appropriate. And if the court has any questions, I'm happy to answer them.
Ms. Hartman, did you have anything additional, or did Ms. Crawford state your position?
Your Honor, Ms. Crawford stated the Secretary's position. We join her argument, but I also am available to answer the court's questions.
Okay, so thank you. Ms. Crawford, let's address that last point that you made first. Mr. Canefield, in his brief, argues that injunctive relief is available through the court. Your response to that?
I think injunctive relief would be the appropriate relief to grant were the court to agree that the ballot language was inappropriate. I think Lane provides good guidance here. That is the only straight ballot language challenge where the language was overturned, and the court in that case granted injunctive relief. But importantly, it did not enter mandamus relief to direct the Secretary and Attorney General to adopt and approve any certain language. I think that would pose real separation of powers problems.
Thank you. Mr. Johnson, Mr. Canfield, when is existing law measured?
Existing law is from our perspective, existing law is measured at the time that the proposition is put onto the ballot. And in that context, Your Honor, so this, just want to make sure I'm clear here. So in Lane, the law was going to basically be void, right? The tax was going away. That was an existing law and was going to be going away. And then they talked about trying to replace it. So just because it was ineffective on a certain date after the fact, did not defeat the fact that at the time that proposition was on in Lane, that was the effective law, or the law at the time. And I think that that's just pretty clear. Also, when you look at Malera and you look at the other arguments about what the law is going to be, and the court has cross-referenced back, obviously in a different context of Title 19, that it's talking about, they're not going to analyze future laws. So therefore, the existing law, what can I actually analyze, is right now. And Your Honor, just real quick on the mandamus, this is also a special action. So I think it's all academic at the end of the day, because I think the parties agree that there's injunctive relief that's possible here. But to the extent that you need to get to it, we do obviously believe that mandamus is appropriate too.
Okay.
And Your Honor, I know that you're going to ask questions. Would you mind if I have an opportunity to respond to what the Attorney General just said?
No, go ahead.
Okay, so real quick, I mean, Ms. Crawford makes reference to the uniqueness of our argument. No, the uniqueness in this case is the ballot language that's being proposed, and that is trying to cross-reference another ballot measure that is on the ballot. That's the uniqueness here. We didn't create this uniqueness. We didn't create this issue talking about effective law, or existing law. I'm sorry. This was an issue that was created by this particular ballot language that we have not seen before. So again, and going back to your question, Your Honor, about the timing. Well, right now, I mean, according to the own proposition that they're citing in their supplemental authority, that would have been at that time the existing law, and the cross-reference again would be appropriate. Ms. Crawford also made again references to the intention of the legislature or the legislators when they passed it, individual legislators. That's not appropriate in Arizona. It's not even appropriate on the federal side anymore either. It's what the intentions of one legislator is completely irrelevant. To try to cross-reference a ballot measure back to the bill sponsor and say this is what they wanted to do, this is what they intended to do, is number one, not within 19125D. It never talks about what the proposer intended. It talks about what the actual ballot language or the actual initiative says, and then an appropriate summary thereof about an impact on existing law. And the existing law is the one area where they have to cross-reference. The reasonableness standard that Ms. Crawford makes reference to does not go to the whole existing law. That's a legal interpretation about the procedure. The reasonableness purely goes to the misleading and the argumentative language and what is reasonable. And in this context, it's not because 145 does not make reference specifically to 212. It is going to impact law until if there's ever a change in the Constitution, it's going to be part of our Constitution going forward. So if there is anything like 212 next year or 2 years from now or 4 years from now or 10 years from now, that's going to be the law of the land of 145. So trying to say that it's just a blocking measure for purposes of 212, which is what the ballot language says, is just not appropriate. I do believe that this ballot language reads like a pro and con argument. And we could be more than happy, Your Honor, those are actually out. Those are on the Secretary of State's website. The judge, Your Honor, could take judicial notice of them, which make these same arguments that the Attorney General and the Secretary of State are saying here. Right? Because it's a partisan talking point, right? It is meant to skew a voter a certain way. And in that context, the ballot language, when somebody's going in there, should not. People have the ability to look at the ballot language, look then at the pro and cons. That's where the argument is. I think it was Justice Timmer and Malera said that's the appropriate place to do this type of commentary and opinion about a different initiative is through those mechanisms, not through the governmental activity of doing a ballot measure. So that's all I had, Your Honor. I just wanted to make sure I had an opportunity to respond to Ms. Crawford.
Okay. So let's look at the first sentence of 19125D. That first sentence where it talks about the descriptive title does not contain language about existing law. Is it your position that the title still has to comment on existing law and cannot include the reference to Proposition 212?
Yes, Your Honor, because I think that you have to read subsection D in its entirety, and it's talking about because the afterwards, the yes and no, and what fills in the blank helps inform what should be in the descriptor of the title. In addition, I think that you are only, and for purposes of that, if you're reading only the first part of D and trying to have that out, it also talks about the principal provision of the measure, and the principal provision of the measure is not to somehow combat or block 212. It's again meant to be law for the foreseeable future until amended. So that's not a principal provision that would be going into the descriptor anyways. But I do think you have to read all of subsection D together.
Well, if that were the case, then wouldn't the first sentence of D somehow incorporate or reference the need for a reference to existing law, which is only in that second sentence, which is the description that falls below the yes and no? I mean, if they wanted the descriptor to include a reference to existing law, the legislature certainly could have included it there, right?
I would agree with you, Your Honor, that they could have included it, but it might have also been, from my perspective, repetitive. But also, I think I would also relay that it's to the concept that the impact of this on another ballot initiative that is pending before the election, the electors, is not a principal provision of the proposed statute. So that shouldn't go in the descriptor.
Okay. So identify for me what language you believe is partisan or argumentative with the exception of the reference to 212. Is there any language that you believe is partisan or argumentative except for the reference to 212?
No, Your Honor. If you strike 212 as we proposed in our proposed ballot language, then I think that you're getting we don't think it's the cross reference to 212 that is both misleading, argumentative, and obviously violation of the statute.
Okay, thank you.
The rest of the language we have no problem with. I'm looking at Mr. Canfield before he starts yelling at me, but okay, he's nodding. Okay.
Okay. And then Ms. Crawford, just so I'm clear, it's your argument that 212 is incorporated within the term existing law because it would have passed, if it passed, it would have passed simultaneously with 145?
Correct. So 212 would pass simultaneously. It's both because of the way that Prop 145 is written, where it refers to nullification of measures adopted by voters on a certain date, and also because of the timing, because they are on the same ballot. Said another way, there would be no other opportunity to inform voters of what would happen if they vote yes on Prop 212 and Prop 145, because this unprecedented legislative referral will have the effect of simultaneously nullifying it at the moment voters voted to approve it, were they to do that. And so really it is a unique function of the way that these proposals interact with one another. And we believe that is squarely within the meaning of existing law. I'd like to push a little bit on Mr. Johnson's statement that existing law is as of the date that the proposition is on the ballot. I'm not sure what that means. Does he mean when the proposition is printed on the ballot, when it's initially referred to be on the ballot? Because as you're well aware, right now, there's still litigation going on about whether either of these will be on the ballot. So under that theory, we can't describe any of it because neither of them are existing law under that framework. I would also say it's not clear if they're saying existing law means law that has been adopted or if it's law that's in effect. So, for example, under their approach, if we have a law that is set to take effect the day after the election, it's been adopted, but its effective date is delayed. Under their approach, even if there were a ballot proposition that said we're going to nullify this law, we couldn't tell voters about that because it's not existing law in that sense. So I would urge the court, this hyper-technical reading makes no sense, nor does it serve the purpose of the statute, which is to plainly inform voters what will happen, what will the law be if you vote yes or no.
Okay, I understand Mr. Johnson's argument a little differently, so I'd like you to comment on this. A law that is passed with a delayed effective date is still a law, correct? Ms. Crawford?
Yes, but I'm simply saying it's not clear whether this would be existing.
Yeah, but his argument isn't that this is a law that has been passed with a delayed effective date. His argument is that this isn't even a law until passed. So can you comment on that?
Yes, Your Honor. The hypothetical about the delayed effective date is simply to illustrate why trying to pinpoint that effective date in the way that I'm still not sure that they have pinpointed doesn't work in the context of this statute. And again, the question for the court isn't to say in the abstract existing law always means X. I don't think it is appropriate to say it's always as of this date because it must take into account what the particulars are of the propositions that have been proposed, because you have things like this where there may be competing measures where one would override the other, but they are simultaneously effective. Again, the purpose of this statute is to tell voters what the effect of voting yes or no is. So being hyper-technical about this is not existing law doesn't serve that end. And our position is this is existing law, both because if it's approved as of that date under Arizona law, an initiative approved by the voters becomes existing law at that time. And that is the point in time that Proposition 145 itself sets, is when the measure is approved by the voters.
Okay, and then Mr. Johnson, Mr. Canfield, how is the Secretary of State to inform voters about the potential for ballot measures with competing purposes?
It's not allowed to, Your Honor. So the going back to what Ms. Crawford said, I mean, if I try to come in and enforce 212 in your court right now, that's not effective law. You wouldn't be, you don't, it's not in front of you. And in all of Title 9 and 9, the cases that we cited, Tillman, et cetera, it's not, we do not opine on law because it's not a law, right? So, but in regard to your question, Your Honor, there is the legislature through Title 19125 has not provided a mechanism to be able to do the cross-referencing that the Secretary of State wants to do here. And probably for good reason. I mean, there's no legislative history and wouldn't be relevant for it anyways, but because then you're inviting the politicking that's inappropriate for elected leaders to do when they're neutrally carrying out their duties. And then we have a partisan ballot language like we have here that mirrors the pro and cons. That is supposed to be partisan. So I think that the legislature's language, and it's not hyper technical. I completely disagree with that. It's the plain language of the statute that needs to be followed here. And so there is not a mechanism to cross references. And that's why in the beginning of the argument, I cross-referenced the propositions from 206 where there were competing propositions, and the ballot language did not cross-reference them. And nor should it, because under the mechanism, not to get too technical again, but if there's two propositions and they compete with each other on the proposition, it's the whoever wins. And then if they both are passed, then you get into an analysis of back and forth, and there's a mechanism to do that. But so the legislature, obviously we don't have that here because it's a constitution and an initiative. So I'm not trying to say that, but in that context, the legislature is aware of this concern and has put out different mechanisms to address it. I don't think that there is not a mechanism in Arizona law to be able to cross-reference ballots. That's the bottom line.
Okay. And again, you referenced partisan language, and your reference to partisan language is limited to the reference to 212, correct?
Yes, Your Honor.
You're not identifying any other language in this description that you believe is partisan.
Well, I mean, correct. I mean, it does say, I guess if you want to say below, right, Proposition 212 below, if voters, and so it's making cross-reference there. But then, obviously they're going to have to come up with some other word or our proposed language in Exhibit A, which is pretty straightforward to make it English. But Prop 212, that is, as well as the below, would be the language that is misleading and inappropriate. So refer you to Exhibit A.
Okay.
Thank you, Your Honor.
Okay. Any last words, Mr. Johnson?
I don't think so. We appreciate your time. These election cases are always fast and furious. I think I might be stealing a little thunder from the secretary here. Obviously, we got the publication date that's upcoming, and I'm sure that one side or another, depending obviously what the Supreme Court rules in the parallel case, might impact everything, of course, but just politely point out the timeline.
I'm aware.
Okay.
Ms. Crawford, any last words?
I'm sure we'll address this with their supplemental authority, but he's mentioned past competing initiatives. There is a method outlined in the Arizona Constitution for resolving directly competing initiatives. This is really unusual here because we have a legislative referral for a constitutional amendment in competition to a voter referred initiative to do a statutory amendment. So there's no question that one would override the other. And plaintiffs themselves had said that those procedures for resolving the conflict don't apply. So that's the reason you don't see cross-references when you have initiative competing with initiative. But that's not anything like this scenario. And the voters should be able to know unquestionably accurate information about what the effect of a yes-no vote will be. What will the law be if you vote yes or no? That's all the ballot language has done here. Thank you.